Hi, I'm Gretchen, Managing Director and Financial Planner at Magenta. In this video, I'm going to cover who should have a power of attorney. According to Alzheimer's research, 1 in 3 people born this year will develop dementia, and 944,000 people are estimated to currently be living with dementia in the UK right now. Living with dementia often means that quite quickly you may become incapable of looking after your personal affairs, and you might need someone else to help with your financial or health matters. Yet relatives can't just walk into a bank and access your money, even if it is to pay for your care. Unless you've got a power of attorney in place, loved ones would need to apply through court, which can be long and costly. I've spoken to several clients this month, some to discuss how to go about writing a power of attorney, but also sadly to deal with an attorney on a client's behalf who now isn't able to manage things themselves. Having these very important documents, which arguably are as important as a will, is really vital, and this isn't just for the elderly. Mental and physical incapacity can occur at any time, so at Magenta we encourage all our clients to plan ahead to ease the potential burden on loved ones. I've personally got a power of attorney because if something happens to me, what will happen to my business? Who will look after my finances, my health, my home, my pets, if I'm incapable? So, what do you do to arrange this? The power of attorney you can now apply for is called a lasting power of attorney, or LPA. You can write an LPA whenever you like, provided you have the mental capacity to understand what you are doing. However, the LPA does not take effect until it's been registered with the Office of Public Guardian. There are 2 separate kinds of LPA now. They cover different issues and you can choose to have only one or both. So here they are. Number 1 is the Property and Financial Affairs LPA, and the second is the Health and Welfare LPA. A Property and Financial Affairs LPA appoints an attorney to make decisions relating to dealing with your bank accounts, handling day-to-day finances, dealing with taxes, and making gifts that you used to make, for example, like birthday presents, to relatives on your behalf. A Health and Welfare LPA appoints an attorney to make decisions such as giving or refusing consent of particular medical treatments, deciding whether you should continue living at home or move into a residential care home. Almost anyone over the age of 18, including your spouse, can be appointed as an attorney, although someone who's been bankrupt in the past can't act as an attorney for the Property and Financial Affairs LPA. You can appoint up to 4 different people. The nominated attorneys can then manage your finances for you when you can no longer wish to do so, or you reach a point where you're no longer able to make decisions. However, for security, for those on the Health and Welfare LPA, they can only make decisions in regards to your health and welfare when you're unable to do so. It is always a good idea to have an LPA in place at an early stage when you have the choice of appointing someone you love and trust to this position. Otherwise, the Court of Protection might have to intervene and manage your financial affairs for you. In this experience, it makes it really time-consuming and complex and can be quite pricey. We're able to recommend a suitable solicitor if you prefer. Alternatively, you are able to make your own LPA online if you're comfortable with that type of system via gov.uk. Before you begin, you'll need to decide who you'd like to act as your attorney and check if they're willing to be appointed. So if you don't have an LPA in place, get on it, talk to a solicitor or do it online. And if you've enjoyed this video, please give it a like, a comment or a share within your network. If you'd like to chat more about your personal circumstances or for us to refer you to a solicitor, then drop me a message. Thank you.